to all our listeners out there, thanks again for listening in. We're super excited for this episode. We've had a ton of recent developments with respect to BOI and bringing in an expert on BOI and the Corporate Transparency Act. So we've all been in the trenches trying to keep up with this law. So I'm greatly honored to have Bill Quick from Polsinelli on the File Forms podcast today. So I'll kick it over to Bill for a quick intro, and then we're excited to get into our topics here for today's broadcasting.
Thank you, Frank. Appreciate you and File Forms having me here today to talk about our collective favorite topic. We've gotten together quite a few times over the last couple of years.
We have
to chat about this, and there's definitely been a lot of in the trenches, out of the trenches, digging trenches, filling in trenches, and other activities. So I don't know where we're at right now. It seems a little more definitive than we've had in the past, but it's still not the death of the Corporate Transparency Act, and it's going to live on and haunt us in new and unusual ways to go forward. So appreciate you having me here. I'm the Corporate Transparency Act chair at the Polsinelli law firm. We have over 1,000 attorneys and 25 offices throughout the U.S. I'm, along with my co-chair, Phil Fagan, heading up our Corporate Transparency Act group here. It has been an insane roller coaster ride, as you are aware, and I'm sure everyone who bothers to listen to this, no one's going to listen to this that doesn't know what the Corporate Transparency Act is. So everybody knows it's been a wild ride since December 3rd. And, I think the ride may be slowing down a little bit, but there's still going to be some upheaval in the future, I am certain. Let me give you a little summary of where we are today, and then we can kind of talk about what that means to everybody. So on March 21st, FinCEN issued their alert and press release about an interim final rule that they have introduced. It is supposed to go into the Federal Register on tomorrow, March 26th. Assuming that is the case, they have set a 30-day deadline for only foreign reporting companies. So that would be April 25th for only foreign reporting companies. And they would only be reporting non-U.S. owners of those foreign reporting companies. So not U.S. owners of those foreign reporting companies. So, FinCEN, they've adopted this interim final rule. They said they were going to do it by March 21st. And by golly, they did on 8:06 p.m. on Friday, March 21st. They sent it out. And it proposes to, in their words, narrow the existing beneficial ownership information or BOI reporting requirements under the Corporate Transparency Act or the CTA to require only entities previously defined as foreign reporting companies to report beneficial ownership information. So further, they said only non-U.S. persons are now required to be reported as beneficial owners under the interim final rule. The interim final rule is intended to replace any contradictory regulations formerly governing the implementation of the Corporate Transparency Act. So it will amend in part, but not the whole thing, of the September 30th, 2022, I believe, final rule on the implementation of the beneficial ownership information reporting requirements. So to effect this, entities previously defined as, quote, domestic reporting companies are exempted from the reporting requirements of the Corporate Transparency Act. And those entities are no longer required to report beneficial ownership information in the Beneficial Ownership Secure System, or the BOSS system. Still wish they would have gotten Bruce Springsteen on board. That's administered by FinCEN. And also, you don't have to report any updated or corrected information, even if you previously reported into the BOSS system. So with limited exceptions, the interim final rule does not change the existing requirements for the foreign reporting companies to file beneficial ownership information reports and associated updates and corrections, but it does extend the deadline for initial BOI or reports if those entities haven't reported yet. And it extends the update and correction period for any of them that have filed previously and need to update those reports to 30 days from the date that this interim final report or rule is reported in the Federal Register. So I said that was supposed to be tomorrow, March 26th. Assuming that happens, then they will have until April 25th, 2025 to make those initial or amended or corrected filings. And then even for foreign reporting companies, so I want to stress this, if you are a U.S. person and you would otherwise fit in the definition of beneficial owner of a foreign reporting company as we reported, they don't have to report you as a beneficial owner, and they can't compel you to provide them information to report on their form. So that's very important. So FinCEN's, presenting this interim final rule. There is a 60-day comment period. So that's until May 25th, 2025. So anyone that wants to comment on this can send their comments into FinCEN through that process. FinCEN has said they are going to collect all that information. They're going to consider all that information, and that they intend to issue a final rule before the end of this year. So, that could be May 26th, that could be December 31st, or if history is an indicator, we could be sitting here at this time next year and still have not had a final rule.
I think what it does definitively, well, maybe not quite definitively yet, because there is still this final rule, but I do think it indicates, kind of where BOI is going and how significantly it shifted. I think let's remind folks that there was originally supposed to be 32.6 million companies that need to file, that was going to populate a database on behalf of the U.S. government that was going to be used for policing money laundering. And effectively now, I think it's 12,000 companies are expected to file. So one of
I saw.
Yeah, like one of my biggest questions is what's kind of the intent of the CTA now that it's been chopped up so much, and now is only going to represent 12,000 companies. It doesn't seem like that's a critical enough mass of data to create any type of transparency per se.
Yeah, I'd be so bold as to say inert and worthless.
Yeah, it's quite a shift. And then foreign reporting companies, it sounds like are going to have to file before the final rule, perhaps?
Well, they should, unless they're going to roll the dice that the final rule changes it and says they're excluded as well. If I were a foreign reporting company, I would do one of two things. I would either form a U.S. subsidiary entity to do your U.S. operations and withdraw your foreign qualification, which I think many may do, or just withdraw your foreign qualification, or make the filing in 30 days. I mean, the filing is not that onerous. Really, and for a lot of foreign companies that are qualified to do business in the U.S. or that have U.S. Subsidiaries, they already have far more rigorous reporting requirements in their own foreign country of origin than is found in the Corporate Transparency Act. I've talked to a lot of those, executives of those companies that are like, well, why is this a big deal? This is pretty routine. It's not that much information. So, I think for a lot of them, other than, having the definitive answer that they have to now report, I think they either will report or they'll do something to remove themselves from the filing requirement.
Yeah, certainly. No, it seems that the whole premise of the Corporate Transparency Act was to elevate the reporting standards of the United States to that of the other kind of major global economies, and now this elevates it, I guess, for a very small group, and it just so happens that group is used to doing this type of reporting. So I suspect that the 12,000 companies,
it will achieve none of the goals that it was set out to do, including bringing the U.S. up to standards of the rest of the developed countries.
Does that set the playing field that perhaps post this current administration that there's a chance, the CTA or some form of it could come back? Is the final rule kind of truly final to some degree?
That's a great question. I don't know. I mean, the thing is, the Corporate Transparency Act is the law of the land, and it says what it says. The regulations in the interim final rule seem to fly in the face of the clear language of the statute. The statute defines domestic reporting company, and they're changing that definition, which I don't know that they have authority to do that. FinCEN is relying on the provision in the Corporate Transparency Act that says that they can establish new exemptions for particular classes of entities or categories of entities, and they've said, well, that just applies to all U.S. entities. I don't know that that holds water or would be defensible in a court. I don't know if anyone's going to bring a challenge to this or not. I will say that on March 10th, there was a letter from Senator Sheldon Whitehouse, who's a Democrat from Rhode Island, and Chuck Grassley, who's a Republican from Iowa, my home state. I'm not there anymore, but he was my senator when I was there. That was a long time ago. So they sent a letter and they requested an explanation from Treasury as to its announcement that it was going to suspend enforcement of the, as they said, Bipartisan Corporate Transparency Act, the 2021 law, considered the most important anti-money laundering law in decades. And then in their letter, they posed two questions and they gave Treasury 2 days to respond, which of course Treasury didn't respond at all, and certainly did not respond in the interim final rule. Their questions were, has Treasury followed or initiated the process required by the Corporate Transparency Act to exclude an entity or class of entities from the reporting requirements? No, they have not. There is a process that they're required to follow. They did not follow that process at all. And then the second question was, what steps has Treasury taken to ensure that any change in the practice or rulemaking governing beneficial ownership information reporting fulfills the law enforcement and national security purposes of the CTA? Again, nothing. They've done nothing on that. So, my thought is if anyone's going to challenge this, and I'm sure there's going to be someone that challenges this, I think those are the first two questions that are going to be posed by anyone challenging this is, hey, you don't have authority to do this and it doesn't serve the purposes of the act. Explain yourself. And you might say, well, who in their right mind is going to challenge this? It's probably not going to be any business owners. I'm pretty sure of that. But I will say politicians are a prideful lot. So I wouldn't be surprised if, some senators challenge this. There are a lot of interest groups that filed, amicus briefs in support of the corporate transparency. There are a lot more that filed in opposition, but there were a few interest groups that, like the FACT Coalition, FACT, filed amicus briefs. I wouldn't be surprised if, some of them come in, file a lawsuit challenging this. And then, perhaps, persons involved with law enforcement or the anti-money laundering aspects may come in and challenge this because they may want that information. But, as has been the case, a lot of uncertainty.
lot of uncertainty, got to remain vigilant. And then also, we also have the state compliance CTA, which, is highly tied to kind of the federal statute. So, it'll be interesting to see what states like New York, DC end up decide to do now that there's been such significant change. New
York has their limited liability company reporting obligations that come into effect January 1st of 2026. I don't believe I've seen any implementing regulations there yet. It's kind of tied to the Corporate Transparency Act, so I don't know what impact that current situation with the courts, et cetera, will have on them. But that one's in place. It's marching toward its deadline.
Right.
California, Massachusetts, Maryland, I believe, all had pending bills in committee. I don't know that any of them have made it out of committee and have been voted on, but they've been percolating the last couple of years. So, I don't know about there. And then, who knows beyond that.
Do you plan on submitting any comments to the final rule?
I don't have a present intent to do that, but I haven't. This came late on a Friday afternoon. I was busy doing stuff this weekend. I read the summary. I'm like, okay, well, I'm not going to worry about this for a while. So, I haven't really dug in and thought deeply about all the sundry ways that they have done things wrong, which I'm already aware of at least 5 or 10. So there's plenty to talk about. I don't know. Maybe. Frank,
Well,
you want to write something together?
Yeah, no, that's what I was suggesting. That's what I was angling towards. I mean,
Yeah.
there's a few different proponents of this that I think we could dig in on, and yeah, we'll collaborate more offline.
There are huge issues. I would say one of the biggest ones is what happens with the people that filed already.
Right.
Does their information stay in this database? How long? Indefinitely? If it's not up to date, is that even? I don't know. They have not addressed that to my knowledge. So
yeah, I'd be surprised if they wiped the database and just kept the private or the foreign reporting companies or something like that. That would be a tricky technology exercise maybe for the government.
And FinCEN's still has a lot of implementation that they were required to do under the act that they have not done, as far as getting the access to the database by the agencies that need the information. That has not happened. If they're intending to continue to maintain the database for 12,000 companies, I guess I would assume they have to do that. I've not seen any inclination or indication that any of that is happening. So I don't know.
Right.
Are people just putting their information in this database that can't be accessed by the parties that are supposed to be able to access it? I don't know.
Yeah. No, I mean, it'll be interesting to see as well, like what restrictions FinCEN puts in place towards filing. Are they going to still collect voluntarily filers who just want to get it out of the way and don't want to keep an eye on this? But ultimately now, I think with the news we got on Friday, it's safe to say that if you're a U.S. reporting company or ultimately a U.S. business owner, you don't have to file a BOI report after a whole bunch of back and forth that we've been following. But ultimately, there are a ton of other compliance filings that kind of fall into the same scope of BOI to some extent. There's plenty of state filings that we've now started to offer as a function of being an original BOI reporting company. So it's a natural ability to kind of disclose this information in the various jurisdictions in which a company operates. And I think, as we get more and more into this kind of multi-state, multi-entity structure, especially with remote workers and companies able to scale nationwide more easily, I think there's inherently going to be a lot of compliance that folks need to stay on track, and ultimately keeping up with things such as annual reports and maintaining a registered agent in all 50 states. I think those are things that a lot of times take a lot of time, and folks have trouble keeping track of it, because as crazy it was with the rollout of BOI and all the little kind of catches with regards to disclosure and definitions, I mean, there's the same level of kind of reporting to a degree at the state level. And, a lot of business owners, I think, struggle with that. Even just thinking file forms, we have to file in 5 different states, and we're a relatively small business. You think of a national company having to track 50 different states, 50 different deadlines. That's a lot. That's a lot of work. So I think it's great to have smart people and smart technologies around to help kind of keep track of these things. And, I think we certainly have been able to add a lot of value for folks who need these solutions for a lot of entities. So yeah, Bill, any other topics or points to clarify as we kind of wrap up BOI potentially officially here? I'm sure we'll do at least one more update on this as we get into the final rule. But any other words of knowledge for the audience here?
I don't know. I think the worst part of this is it's not the end of the story. I mean, it would be so much easier for everybody if this was just the end, but it will carry on, unfortunately.
Yeah. No, we certainly want to continue to provide folks the education they need to kind of keep up with these things, and we'll be the first, I'm sure, to report on it. It's been great building the community of CTA warriors on LinkedIn and covering all the various updates that at times were literally daily or nightly, I should say. So this has been terrific, and please do reach out to Bill, reach out to myself to kind of get any questions, answers after listening to this show. And we'd love to work with you and serve you in any way we can. So thanks again, Bill, for joining us.
Thank you, Frank.